Is it going to be in charge of civil matters or criminal matters? Mr. Speaker, I am asking rhetorically. Respected Leonard, you must listen to me. You have your opportunity to have a bite. This is unfair. Respected Leonard Attorney General, first gentleman at the bar. This approach is wrong. This is wrong. You have your bite. You have a bite in the mic.
Honorable Minority Leader, Honorable Attorney General, please, both of you should resume your seats.
I'm your senior.
Honorable,
but I'm your senior here, and I'm your senior here.
Both of you should resume your seats.
Therefore, I wrote Samaba. Now, Tiablucha, Tiasma Mekan ye. Meno Casa breaking news to say John Dramani Mahama and the Parliament, MDC4, Ako Passe, Emrebi, Nasamrano, a very draconia. Sambakaya, Embrebi Kwame Nkrumah what the Detention and Preventive Detention Act, PDA, Ebai, Ebechichi Ghana Fogum, Abusia, Arahu Samaba. Stay tuned.
Asamaba! Wakani Hubio!
Oko Parliamenta, a Jana Noaso, the Asem Nessi, yet to a mem, yet the Abaya NDC, Mahama sa 4 years, Yehudi Omaye, the Mahama na Abaya and set. Ombeka Ghana for Anwatum. And Niama Kwame Nkrumah ye, JJ Rollins military status. Kwame Nkrumah de Preventive Detention Act by a PDA. Ebechiche Ghana for Gumu, so who you be a Varanda boys. I know Yabechira Nyakwacho. And no na John Dramani Mahama say or no. And I'm so person was at do a man boss wintino. Or say or the tribunal abba. Na tribunal no the abana no because of say what they fight be papa because you were called to be brave wo munya dwuma bianye na mumsa say tribunal no the be dey ye kwanya wo fa so a hu yo bia hia na ndisi ni akobo amane we wo sika no ho ye machine asante ni we wo sika no ho ye machine sade Nkrumah ye na Rollins be ye bi no eno na ndisi e de abai ye catch me the beginning say John Dramani Mahama sa supreme leader act no and we supreme leader and we number of parliament obi so want me nyare Mahama be take him by surprise because Sagan wo kasa kura utu say or ye conman John Mahama kasa utu say akwa we yankasa no or ye dadafo na Ghana for will pay the price but uko parliament enra e jane so parliament e bra we so be pass sa bill no NPP for no ka tro mo say sadi yo mudi bayi mo ba be create problem ama manfo be brebe dwan African country nim e be ma Ghana ho akere no na se mo amani afi no muntie ye ne ma wiase from 60s eba ya besi 70s ebesi 80s mo hu de course wo man no eno na Kwame Nkrumah eye na Mahama so akoye na uya utia bruchira fa ho adwen sa utia bruchira fa ho adwen TUC force Mahama nya de oye no na wo fi so be dadai but ebedumre bi no Ghana for ebetwatro NDC wo betwatro ato MPP for so wo yo bi ehye no akoye ne de wakogina ho ne akofa NDC for nkwa to se mimisi a be kasati ya Mahama suba mfo kankan no ne de makogina ho na NDC for asate panel ne de wasem ne de wakotom na no na afanyoma kens ejina ne na so oni atoni general no Mahama akofa na ba no o ma bi ni.
Is it going to be in charge of civil matters or criminal matters? Mr. Speaker, I am asking rhetorically. Respected Leonard, you must listen to me. You have your opportunity to have a bite. This is unfair. Respected Leonard Attorney General, first gentleman at the bar. This approach is wrong. This is wrong. You have your bite.
Honorable Minority Leader,
in the mic.
Honorable Minority Leader, Honorable Minority Leader, Honorable Attorney General,
and
please,
both
of you should resume your seats.
I'm your senior.
Honorable,
but I'm your senior here, and I'm your senior here.
Both of you should resume your seats.
Chaos. That is what the tribunal will do. What you are doing is what the tribunal will do. They should let us speak.
Both of you resume your seats.
The tribunal system. This is the tribunal system. This is the tribunal
Honorable
system.
Minority Leader, Attorney General, both of you should resume your seats.
Tribunal system of justice. Tribunal system of justice. That's what you are practicing. That there's supposed to be 2 minutes, has to be brief. Mr. Speaker, this is a government that is seeking to use the legislation to create an analogous justice system.
Honorable Minority Leader, your amendment must be for the consideration of the House.
Mr. Speaker, it is so. I need to carry them along with respect, sir. I need to carry them along. So, Mr. Speaker, let me finish my argument. I will finish it in all humility, sir. Mr. Speaker, I contend that creating this new tribunal system by this provision, Mr. Speaker, will bring chaos to the justice delivery system we have in our country. Mr. Speaker, this is populism. We need clarity. Justice must not just be done, must be seen to be done. Mr. Speaker, I remember the famous case of Tagore and Issa Abbas, where the respected Dr. Dominic Ayeni took the matter up at Court of Appeal. These were individuals who were convicted. And at the Court of Appeal, his argument was that a man may not just be convicted because of his own words. That is populism. He argued. He said every element of a crime must be proven. Lead evidence of probative value. That was the argument of the respected Dr. Ayeni. It was because we had a clarity, certainty in the law. We had a Court of Appeal well properly constituted. Today, you want to have a tribunal? A tribunal. Populism, Choboy justice. Choboy justice. Mr. Speaker, Choboy justice, where people will be sent and people will be thrown into jail. Mr. Speaker, I will not sit here as a minority leader and allow this provision to stand. I move that this provision be deleted. Mr. Speaker, I so move.
With keen interest the debate both in Parliament and in the media over the Tribunal's bill. The TUC has equally examined the bill and has consulted widely with various stakeholders on the matter of regional and district tribunals. In the TUC's memorandum to the Constitutional Review Committee, we noted in paragraph 14 as follows: regional tribunals, that is Article 19, 2B and 142, are no longer relevant. The TUC recommends that the entire article and other consequential references to regional tribunals must be expunged from the Constitution. In this final report to government, the Constitutional Review Committee recommended that the regional tribunals be de-established from the Constitution. In the considered view of the committee, the High Court has been handling the caseload of the regional tribunals. In the face of these clear recommendations, both by TUC and the Constitutional Review Committee, it is baffling to us that government is attempting to activate the tribunals. The TUC is manifestly opposed to the idea of resuscitating tribunals, given our collective bitter experiences with tribunals. The tribunals bill in its current shape and form strengthens our conviction that tribunals must be abandoned. The bill, when passed into law, can be a potent tool for weaponizing justice delivery and entrench the perception held by many that our justice system is up for grabs by the politicians. We call on the President and Parliament to heed the advice of the Constitutional Review Committee, and government must halt the current legislative process of enacting the tribunals bill, expunge regional tribunals from the Constitution, and take meaningful steps to properly resource our judiciary. If law is properly seen as an embodiment of our collective historical experience, then the recent history of public tribunals must lead us away from any attempt to re-establish regional and district tribunals. The bill must be withdrawn from Parliament. I thank you for your attention. To review the 1992 Constitution. Ladies and gentlemen, we had expected government to publish the full report of the Constitution Review Committee. What we currently have is the summary report of recommendations by the committee. The full report has not yet been published. We had also expected government to publish its position on the recommendations before any action is taken on changing the Constitution. This will form the basis for public debates and consultations, leading eventually to amendments of the Constitution. Instead, we now have government taking portions of the recommendations to Parliament and seeking to amend those portions of the Constitution. The TUC find this approach problematic and unhelpful. The approach detracts from all known principles of transparency. It undermines the integrity of the entire constitutional review process, and surely the approach does not inspire confidence. The TUC is therefore demanding that government publishes the full report of the Constitutional Review Committee, and government must also publish its own position on the report. Government must stop the pick and choose approach to reviewing the Constitution.
Thank you.
Yeah. Ladies and gentlemen, I now turn to the Tribunal's hearing.
Good evening to you, ladies and gentlemen of the press. As you're already aware, in the chamber today, we commence the consideration of this so-called Tribunal bill. Our contention as minority is that this bill seeks to create a parallel system, an analogous system, unbeknown to the Constitution, if we read all provisions of the Constitution as a whole. It is true that mention is made to tribunal system in our Constitution, but context must be interpreted within the broader scope of Articles 125, 126, and 127. We have a judiciary system, district courts, circuit courts, high courts, court of appeal, and the Supreme Court. If there are issues with the system, the way to go is to reform and to resource, equip, and retool. It is not to create a parallel system with coordinate jurisdiction. Now, if you look critically at the clause 4, which was the subject matter of this long debate, basically, you look at a new adjudicatory body where you say one person presiding as the chair must be a lawyer, but the other two must be non-lawyers. And they are going to preside on criminal matters. We reminded Dr. Ayeni himself, the Attorney General, that when he was in practice as a private practitioner and he dealt with this case of Tagore and Issa Abbas, the Republic versus Tagore and Issa Abbas, he argued forcefully that a judge sitting in a criminal trial must ensure that prosecution lead evidence of probative value proves all essential ingredients of the offense. That was his argument at the Court of Appeal, which was upheld. That to deliver justice is not about chobe or media headline scream. It's not about how the public perception about an individual is, because that can be misleading. Now, what we see in this whole exercise is to create a system where people would be pronounced guilty even before their case is properly determined. No established procedure of ensuring fairness. And it is not only the minority that is complaining. Today, organized labor has come out loudly to re-echo its position on this matter. That we don't need a tribunal system in our country anymore. Tribunal system, we know what happened in the PNDC era, where people were targeted, assets were seized, and those people who claimed they were tribunal members enriched themselves. We know that record of the NDC, their predecessor PNDC. So we, the minority, have left the chamber because the majority leader decided to shut the door. In Parliament, we believe that in all situations of disagreement, there must be a window to discuss, to raise the concerns. But once the majority leader makes a strong pronouncement that whatever the case, they will not listen, they will use their numbers to pass the bill, then there is no point again. Every other effort will be rendered odious. Every other effort by us will be rendered nugatory. You recall that earlier in the day, when we raised this issue, the majority leader, realizing that he didn't have the numbers, immediately called for suspension of the House. So he used the 5 hours to marshal his members into the chamber. Even so, those present were not even up to 115. They were 113. We, the minority, counted them. They were not up to. Yet, those who counted claim that the NDC members were more than that. You are the media. You can get in and do your own check to validate what we are saying. We tell you truth. We will not say anything outside of the truth. So it is clear that the Yentio syndrome has set in. They don't want to listen to anybody. And this is for say, Omuntio Bia. Omudisa choboy, sesebi, asem tu obi, no omu kobo obi kwedua. Omu asese omu party member say, omu kodi nasem. Omu ko sizi nkrofo eja pade, edi nkrofo kotu efiase. Omu endi omu asem ye. Ye nyina ye nim say ye court system no wo hodada. Ghana no ye wo district court. Ye wo circuit court. Asem ni ye wo da wo high court. High court di wasem so na wo mpene sa wo court of appeal. E wo high court system na mu no ye create specialized courts. Matrimonial causes ye wo ne court wo ho. Financial crime ye wo ne court wo ho. Ye wo commercial court, ye wo land court. Ye wo court a ehwe specific nsɛmsɛmu. Anything no ehun yesa wo si na wo the tribunal a sebi omo betena so omo di asɛm no. Omo ye lawyers. Wo se ene de emfa ho. Mo kwakwa ye choboy. Nti no sa let the blood flow na ekunkum nkrofo no. And this for say eno no mo de ba. Yen de ye party NPP. Yen gina so a ye di PN say sebe amembuo ye de mbra ene ye de yo. And the TUC, organized labor, omusu aye press conference akasa akache omampeni John Dramani Mahama nina ban say sa tribunal no embo Ghana e de ani bre ni hawon yawo ni sebi obi mpe wasem a na wakobbo okwedu na obediu etutrosem enti no omunjai ya nuanu mendisi for say oh omo de omo nti obia ye kan den sen ye kan sen omo de embra no omo be passe because omo nim dia omo hwehwe yen ya sede ni say politics yen ntokwa ya kire ya adwen yen tumi ntina dem wo a Ghana mbra no omo aye omo adwen so omo mfa ye adwuma enti ne ye pie ye mpie sebe ye sorry ya na ye boycott there bi enye sa na tie majority leader nenum asem a oka ye say ye den a ombe pass omuntie yen meaning say organized labor omasem omukan omuntie other civil society ensem omukan ye no omuntie constitutional review committee na kasa no e can be fast our tribunal system and over 15 years and over 16 years our tribunal ye twom dada. In fact PNDC form year transition no ferry ntina omo share da ekipi sa tribunal no constitution mu but for a long time yemfa sa tribunal de no enye adwuma all of a sudden mo se mo the tribunal bi ba na wo kan embra no kra na judicial council na was to me say obe determine san nyoma no mo se committee bi ese so omo ebenya oversight na sebe Ghana Emma NDC for to me say Omunfa embrano ensho munsem omunye de omupana. We ye a form of kangaroo court bia. Omudi ba omudi embra edibe bakeno. We don't recognize such courts. We don't. And yasemwane say, as I say Ghana 40 ase. Reasoner ye di pie reasoner amambuo na ekoso ne ye gidi se enkoyie na ebia bibi nti ye nuanom NDC for no mu di bibia hyehye omasum omu ntie omu nten soso dia omu fi se omu ye no ene na omu ye sebe ende Ghana no it is wunya NDC ni a wonka ho wunya NDC ni a wokasa omu ntie nti no yasemwane se emprempre se omu aye omu adwen se omu ntie no yen ntena ho na yeni omu enye nkitahudie bi e wo sambra no because omu se omu ntie enu nti na ye di pie ye yeda mo ase